The media, both Hollywood trade and Wall Street, can't really seem to get anything right when it comes to interpreting what's actually happening with the Walt Disney Company and its two cases, one in federal court and one in state court, against Florida. The governor, Ron DeSantis, and the Central Florida Tourism Oversight District, which was legislatively put in place to get rid of the former Reedy Creek Improvement District that was, frankly, abused by the Walt Disney Company for nearly 60 years. And we've got some special guests today to help us discuss the legal implications of this and what's right and what's wrong. Stay tuned because, well, we all love watching Disney take the L's. Renegade Online. Well, folks, welcome back. Another great day here at Valiant Renegade. It's good to see everybody out there once again. And if you are like one of the many folks watching this video, not yet subscribed to this channel, please take a moment and turn that little red subscribe button to gray. Hit that like button, hit that notification bell, share this sucker out on the social medias, and of course, please do leave a comment before you head out the door today. Make sure to join us every Sunday afternoon at 6 p.m. Eastern right here on Valiant Renegade for the live show. Also, make sure you check out the new merch store. We'll leave a link in the video below. And today, speaking of merch, we've got a special. We're running a BOGO special here on Valiant Renegade. If you buy one attorney, you get the second attorney for free.
Merch! Merch!
We've got
the
joining us...
mouthpiece.
Oh, God. The great Ron Coleman of Coleman Nation Podcast, and, of course, our good friend Andrew Esquire, the legal mindset. We've got a few things to discuss here. This was too much fun this week. Let's kind of dive straight in. Let me set the audience up. The first thing I thought was funny, Andrew, if you want to briefly comment on this, we've got a delegation of legislators from Orange County, which is the more liberal county in Florida, that's trying to get something on the floor to overturn what was done before. From this point forward, we will refer to them as the Cry Harder delegation from Orange County. Andrew, do you want to touch on this as we get into the main topic?
Briefly, this has been led by primarily Linda Stewart, who couldn't reason her way out of a paper box, backed up by Escami, or Escami, however you want to say her name, but they're the ones that were constantly, and if you go back and look at the legislative record, they were constantly trying to make amendments to protect Disney. When the Reedy Creek bill initially came through last year, they were trying to alter the amendment and amend the act repeatedly. In fact, Stewart, who's the one who filed this, actually filed the exact same amendment, which is pretty much to delete the entire thing and prevent it from happening. Now, the funny thing was, and we watched the entire local hearing on my channel and just roasted the heck out of it. She didn't even understand the procedure to get a bill considered by the state legislature. I'm not making this up.
I believe you.
Go back and watch the video. She literally did not understand. And the Republicans were like, you understand the deadline has passed to file this bill, and we can't even consider it, even if we wanted to. And not only that, but there was actually no local representative who was sponsoring the bill. There was no House sponsor for the bill because the House sponsor is actually a Republican who supports the action of DeSantis, supports the Reformation, and did not support her motion to restore Reedy Creek. And now what she wanted to do was she wanted to roll back the clock, go to 1968, give them back the powers of the nuclear power plant, remove the requirement that they follow sunshine law, transparency law, modern ethics law, remove all that, go back to the original governance, take away the impact fees, which they're now required to pay. So give Disney all of its subsidies, exemptions back. Of course, that was blown out of the water by the House Speaker, who said, they're not even going to consider this because it follows none of the proper rules of procedure and nobody wants it. Now, this vote, by the way, to be clear, the local legislators did vote in favor, but it was a split vote. It was 5-4, and there was a significant pushback from all of the senior legislators, which said, look, procedurally, this is not even going to happen. And of note, one of the legislators on the Democratic side literally repeatedly confused Reedy Creek and Disney. And it seems like she was told by Disney they are one and the same because she used them interchangeably and kept quoting, well, isn't this them taking away private business? Isn't them getting rid of private business? Not understanding Reedy Creek was a government. I'm not making this up. This is your Democratic
confirming the entire purpose of the legislation, rolling back this grant of a fee in what is it? What would be the medieval equivalent?
A fiefdom.
A fiefdom, a Magic Kingdom fiefdom.
Yeah.
It confirms everything they've said, and it confirms exactly what the CFTOD audit said, which is this is agency capture. This is the capture of a government by private industry because they intended to confuse people, and this actually proves it. So this could not have been a better present for me for the New Year's, just to have fun and make fun of it. We died laughing. You can go back and catch that on my stream. You'll see a big picture of Linda Stewart. She's a woman who looks like a troll, so you won't miss it if you want to go back and check it out.
Andrew, not everyone can be good looking like us guys. Come on.
I'm sorry. Not everybody's got a great SIG hat.
There was a famous a U.S. congressman from New Orleans during Katrina that was busted by police and then led to a massive issue for this individual when they found $90,000 of actual cash wrapped up and stored in his freezer. I don't know if you guys remember this.
We have our own Bob Menendez here in New Jersey.
I'm wondering if
bars of gold.
Yeah, I'm wondering if this chick in Florida from Orange County doesn't have a stack of Mickey Mouse bills wrapped in cellophane in a freezer somewhere.
I would be concerned if I were her to have folks looking into her, because if she thinks these actions are permissible, I don't want to know what benefits they've been giving her that go around campaign finance rules. I'm not alleging anything, but I would not want to draw attention on herself. But Disney, throughout this process, what they've done is they continue to draw attention to things they really shouldn't be drawing attention to. Because if you look too close, you start to see problems. They should just be quiet. And if they had been quiet the entire time, which I believe was Chapek's plan initially, I think they would have been all right. I really do think they would have been all right.
But Andrew, it's a whole new ball game after the 11th Circuit. It's a whole new ball game after that 11th Circuit decision.
We're getting there. We're getting there. That's the next thing coming up. And the reason we brought that up, and Andrew, as you correctly pointed out, the conflation between Reedy Creek and Disney being one and the same has been a massive problem for this entire legal proceeding for the last year and a half, or however long it's been. 2 years now, almost, I guess. Almost 2 years in April, which is amazing. We've been covering this since then. But we've even got not only attorneys for Disney and the CEO of Disney that constantly conflate these issues, which are ridiculous, but now you have even legislators from Florida, the state house of Florida, that can't get it right. This is how bad things have gotten. And that brings us to this case here. And, once again, this is from the street. This is a financial publication. This is a Wall Street trade publication. And again, the people out there in Wall Street, they don't understand this either because of continued, frankly, bad reporting like this. But not only that, we've got the CEO of Disney and Disney itself who is conflating these, attaching what's going on here to their own case, saying, look, Judge, see, it's the same thing. Let's talk about why it's not. So, Andrew, if you would like, bring us up to speed on what's going on here, and then you and Ron kind of dive into it from a constitutional standpoint.
Sure. So what happened here was there was actually a appeal to the 11th Circuit Court of Appeals. That's a federal circuit of appeals. And this is regarding Mr. Andrew Warren, who was the state attorney for Hillsborough County. Now, back last year, I believe, he was removed from office by Ron DeSantis, and there was a whole press conference, which I'm going to have a video which shows part of that press conference, the material parts of that press conference coming out on my channel quite shortly. But you can see where in that video that they removed him from office for essentially dereliction of duty. He said he was not going to uphold certain Florida laws regarding abortion, regarding transing of children, regarding enforcement of criminal penalties against certain folks. And that's the law in Florida. So he said, look, I am not going to follow the law in Florida. And for those reasons, he was removed from office. Now, the district court said that while there may have been, he subsequently challenged this. And of course, this is, by the way, an elected official. He challenged this. The district court said, well, there may have been some constitutional infringements regarding some of the reasons why he was removed, but there were more than enough non-protected reasons to remove him. So we're going to allow this. The appellate court said, well, hold on there. We don't necessarily agree, and we don't think you can look past the constitutional violations, you need to take that into consideration. So they remanded it to the lower court for him to consider whether the non-violative reasons alone, the permissible reasons, were sufficient to remove him from office. So it's not saying yet that he is due damages or is due to be restored to office or anything else. It's just remanding it to the lower court. But Disney thinks that there's some precedent regarding First Amendment because, as part of this case, he brought up First Amendment and free speech regarding these policies that would be applicable. So Disney is saying, well, our only remaining federal case, and they filed this case law with the federal circuit, with the federal court, is First Amendment. So they're saying, well, look, this says First Amendment, and we're arguing First Amendment, therefore we're protected.
Yep.
Therefore, what we did is protect.
Also, DeSantis.
Yeah.
DeSantis, yes. Common denominator, Ron DeSantis.
I'll have you comment more on that in a second. Ron, let me ask you this, though. So basically what we have in this case is we have an elected official, a state attorney in this case, that, as Andrew points out, effectively said, I'm not going to do the job I was elected for. I don't want to do my job. I know these laws are on the books, and my job is an attorney. It's not a legislator, but I don't want to do my job. How does that usually play out, Ron? I mean, does that work?
So, well, it doesn't work for the people who live there, but it works politically. Unfortunately, there's almost never any recourse. I mean, there should be. There are legislatures that should be able to deal with this sort of thing. There is no right in the constitutional government, in a Republican form of government, for a prosecutor or a chief prosecutor, be it a state attorney or a district attorney, to announce what laws he will and will not enforce. This is a new development that we have in American jurisprudence, that legislatures are letting skate, but it's preposterous. It's a great offense to the rule of law. But as Andrew points out, what the 11th Circuit says here is, we're not saying that's okay. What we are saying is, if there was a First Amendment infringement, and we have to keep in mind here that unlike most employees who can be fired for what they say, a government employee cannot be fired for what he says, because that would amount to the government itself engaging in viewpoint discrimination. So if you work for a state university, if you're any kind of government employee, which I think pretty soon will be about half of the people in the country, then you can't be fired for expressing your opinion on a view, even if your employer thinks that in other words, that the person senior to you in the government believes that it may affect your ability to do your job. Now, when I say employer and fired, as Andrew also pointed out here, one of the big concerns of the 11th Circuit was, this is an elected official. So not only is this someone who works for the government, the way the guy on the snowplow passing me by here does, but this is someone who has actually been elected by the people. There's a higher standard there to get rid of it, even though Florida law is unusual in this respect, and it gives the governor the power to do what chief executives ought to do, or ought to be able to do everywhere, which is to say to someone like a district attorney, if you're not going to enforce the law, you seem to be in the wrong position. You're gone. Florida law gives you that power, but because it's an elected official, there has to be a little bit more attention paid to the question of whether there's been an infringement of his free speech rights.
Yeah, and we've seen this before for people who have paid attention to things like federal judges, or especially Supreme Court justices that have gone through the advise and consent process in the United States Senate, where they ask specific questions, about, well, what's your opinion on this, opinion on that? And you'll see these people say, well, as this is a case that may come before me, were I to be appointed, I don't want to comment on this, right? They don't want to go out there on the floor of the Senate and testify that they're going to pick and choose which laws they want to follow and replace actual justice with, say, social justice, where they get to make their own decisions from the bench. I mean, I know we've had a lot of justices and Supreme Court people and federal judges do that over the years. It's wrong, but this basically what this guy wanted to do. But here's the thing. Disney is now officially, trying to, they're attaching this to their lawsuit as evidence or as precedent or some, I may be using the wrong legal phrase.
Supplement. It's legal supplement. The judge can decide whether or not to use it or disregard it. It's not yet at the phase where the judge is required to consider it. In fact, the judge may very well look at it and say, well, this is completely irrelevant, which is what I think the judge should look at it and do. But even if he does look at it and say, okay, well, let's take this at face value. Was there a permissible reason for Ron DeSantis to reform the district? Well, if you look at the CFTOD audit, there's 80 pages of good reason to redo the audit, including several potential crimes. So you've got plenty of reason that is permissible, any one of which, just one of those reasons would be fully sufficient to reform the district. You've got dozens of them with backup and proof. So just because of all of that, I think that just distinguishes.
But there is a pending motion to dismiss, and I don't think the audit is before the court, and I don't think it could be before the court because it would constitute hearsay.
Yes.
And you're talking about, Ron, just real quick for the audience's sake, you're talking about the motion to dismiss that was filed by CFTOD on the federal case that Disney filed with the First Amendment claim, right?
Right. So as we all know, Disney dropped their other claims. They're down to this First Amendment claim. They filed a notice of supplemental authority saying, hey, look, First Amendment, court, judge, DeSantis, same thing, right? And no, not the same thing, not even remotely related. And there's an important point here. It's one thing if you're Donald Trump, in which case judges permit you to drag things from any court, any proceeding, even the January 6th kangaroo court, show trial, whatever it was, into your court and make findings of fact against him based on preposterous sort of proceedings like that. But
especially if you're a prosecutor from New York, so
whether it's New York or Maine, but regardless of what happened here, one thing that didn't happen is no finding of fact of any kind about Ron DeSantis has been made. And if it had been made, it still wouldn't be applicable here because it was the finding of fact would have to be in order for what's his name again?
The prosecutor,
Andrew Warren.
Andrew Warren, yeah.
Warren, yeah. In order for him to ultimately prevail in this claim, he will have to show that there was this whatever the standards are for the various claims that he's making. If it's a Section 1983 claim under that his First Amendment rights were violated, he will have to show that under color of law, he was fired in violation of his First Amendment right. That's got nothing to do with Reedy Creek being the legislation being in any way motivated by a First Amendment prohibited animus. And by the way, since when does Disney have a First Amendment right to be or to own or to control a tax district?
Yeah, and that's just, Andrew, and on that note, as we kind of wind it down here, that's one of the things that you and I have discussed over and over again, and great opportunity here for your final thoughts. And to remind the folks, is Reedy Creek, or the former, we'll call it the Reedy Creek District, was that ever owned by Disney? Was that ever a corporate subsidiary of Disney, Andrew?
It is a public corporation, which is called a government, right? It is a government of the state of Florida. It is a piece of the state of Florida. It takes a delegation of the state of Florida's power, but it in no way, shape, or form was ever a subsidiary, affiliate, or entity underneath directly the Walt Disney Company, as much as Walt Disney likes to frame it as such. And they do a very good job, a very efficient job for the last 60 years of confusing folks about that and making it seem like a subsidiary, to the extent that they even have a actual subsidiary called Reedy Creek Energy Services, which is the contractor that provides these services by contract with Reedy Creek Improvement District, and they intentionally blurred that line. So while it may be a little blurred, but under Disney's intent, in reality, there is absolutely no affiliation there. So any action against Reedy Creek is an action.
But in real reality, they absolutely treated it like it was their corporate property.
Yeah.
Correct.
But there's nothing, and I always tell folks this, is that if you look on Disney's balance sheet, if you go through their tax returns, if you look at their books, if you listen to their earnings calls, they have many, 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 many corporate entities, hundreds and hundreds and hundreds, not just a few studios or ESPN, but beneath that, even more. Reedy Creek Improvement District is not among them anywhere. It is not owned by Disney. So by default, I mean, if a legislature takes action against one of its special taxing districts that's not owned by Disney, and none of them are, then how then can you say that Disney was violated? Nobody closed the parks down. Ron DeSantis didn't levy a special tax on Magic Kingdom tickets for 2024. There was nothing of that nature. So again, trying to make this connection, this is all for media show, and a lot of the media is just gobbling it up, eating it. Andrew, what do you think?
Well, I think they're taking the lines that are fed to them by Disney, which is very par for the course for the media over the past couple months. We've seen it time and time again. And frankly, I don't mind, because it gives me fodder to mock and make fun of them as they have their horrible takes, clearly not consulting with anybody who knows anything about this area of law, or even just understands, in this case, basic constitutional differences between an individual's elected position and a corporation with a separate government. I mean, it's the same as saying that Seattle, that Starbucks has right to govern changes or intervene in changes with Seattle, right? Any large corporation, Coke in Atlanta, right? They have the same standing that Disney would with Reedy Creek and Disney. It doesn't matter that they're a larger percentage. It doesn't matter that they're in the majority. The jurisprudence would be the same. And to rule Disney's way would open up an entire can of worms in America. That would be absolutely insane in terms of case precedent, which is why I continue to say that there's, in the long run, there's no prevailing for Disney on this one.
Yeah, exactly. And final issue on that, since you brought it up, and I just want to remind folks that, again, I think, Andrew, as you've made the comparison, Ron, as you've made the comparison before, as they're making the case in court for the Central Florida Tourism Oversight District, what would give, I mean, where in any legislation and what judge in their right mind would rule in favor of this notion that a public government, a public taxing body that was sanctioned by a state legislature and put into effect, could effectively unilaterally turn over its power to a private corporation in a homeowners association agreement, whoever they try to get this under? I mean, if you approve that here with Reedy Creek, saying that this midnight appointment, this 11th hour deal that Disney foisted on the former RCID, saying turn all your powers over to us before Ron DeSantis walks in here at 8 o'clock tomorrow morning, and have that stand up in court. Gentlemen, what do you think?
I mean,
What do you think I am, a biologist?
Yeah, I mean, look, I think that there
are anything is
go ahead, Ron.
Anything is possible these days. I'm sorry. I'm just saying anything is possible, but in outside of La La Land, outside of black is white and white is black, where we do see things that are unbelievable and that we would never have predicted. But as you and Andrew have been discussing, no way.
Yeah, the precedent that would set would be crazy. Andrew?
Yeah, like I agree with Ron. Anything is possible, right? But in this case, my probability is they're going to take an L on this. It's just a matter of when, at what time. And we've actually seen Disney is very good at procedure. They're very good at stalling. They've done a very good job at stalling in the state case and delaying rulings in the state case, as well as burying them in public records requests. And I've given Disney credit for that from the beginning. Their lawyers are very good at procedure, and they're very good at bouncing around with venue. They see they did that, moving stuff from the federal to the state case. This is par for the course for Disney. So don't underestimate their ability to drag it out. But I am really talking on my channel about the substance in the long run. And I think that is where Disney loses. They lose in the substance in the long run.
Yeah, and make sure
Here comes
everybody...
the plow.
One last joke before as we close out here from Ron's getting some snowmobiling going over there. No, thank you, Ron. Thank you, Andrew, for being here. I agree with you guys. Look, I think in the long run, Disney is going to be on the short end of the stick. They've been taking L's on this for nearly 2 years. Nothing's going to change, but they are going to try their damnedest, as Andrew pointed out, to push this in the media, spin it any way they can until they can spin no longer. And then when the case doesn't go their way, they'll do what Disney does best. they will make it disappear. They will memory hole it in the media and they won't even talk about it. It will just go away. They'll make a final statement, and that'll be that, and you'll forget that Disney once again done screwed itself. Gentlemen, thank you for being here. Make sure you check out Ron Coleman and the Coleman Nation podcast. Make sure you check out Andrew Esquire, the Legal Mindset, who had a video coming out earlier this morning on some of this topic matter. So we'll put a link into the video description as well, and appreciate y'all being here. Gentlemen, thank you so much. Take care of that cold weather, and until next time, see y'all. Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.